We start with the question of equal protection. One question that came up was whether or not the differences between male and female athletes was simply a question of hormones and puberty.
I mean, one thing that this case could be about is, and in this case I mean generally, this litigation, is whether the plaintiffs are right here that there is a mismatch, right? You know, and some of your briefing addresses that question, right? You can take all the hormones in the world. You can take all the puberty blockers in the world, you say, and there still will be a competitive advantage. That's one thing that this litigation could be about and one way to resolve this litigation.
But is puberty and the hormones that come with it the only differentiator between the ability of male and female bodies? It was rather difficult to find sports records for prepubescent children that had verifiable data. What I can say is that even as early as middle school, the record for boys in track and field are significantly quicker than for girls. In the 100-meter dash, the record for middle school boys is 11.58 seconds, while the record for middle school girls is 13.0 seconds. However, those records do not include the age of the child, so I'm not sure if those records were pre- or post-puberty. Justice Kavanaugh asked about the states that allow males to play on female sports.
How many states allow biological males who identify as females, transgender women and girls, to play in women's and girls' sports?
Statutorily, I'm aware of 27 states that take our side and do not permit that, and 23 states that take the other side and do permit it.
And those states who do allow it, is your position that they are violating the Constitution, the Equal Protection Clause, rights of biological girls and women by allowing that? Or do you say that's up to each state to decide and that the Constitution gives discretion to the state whether to allow it or not to allow it?
I have not yet been persuaded by a constitutional theory that would let us use the Equal Protection Clause to impose our policy on other states in this matter.
Justice Kavanaugh wasn't asking whether other states should adopt Idaho's position. Remember, the question before the court is not should males be allowed to participate in female sports, but do states violate the law when they prohibit them from doing so?
And remind me whether Idaho's law, and I guess your answer made me think of this, and I guess this goes to the question of whether the law discriminates on the basis of trans status. Is it true that biological girls, trans boys, can play on boys' teams?
Anyone can play on boys' teams, Your Honor.
So Idaho's law does not discriminate based on transgender status. Both Idaho and West Virginia laws do differentiate based on sex, something required by Title IX. Nothing in the law of either state prohibits a person from participating in sports, only preventing males from participating in female sports. This seemed to confuse Justice Jackson.
Yes, and I understand that, and there are legal arguments. Let me ask you something about the classification. I guess I'm struggling to understand how you can say that this law doesn't classify on the basis of transgender status. The law expressly aims to ensure that transgender women can't play on women's sports teams. So why is that not a classification on the basis of transgender status?
I'd apply Skrmetti again. The question is whether the application of the law turns on transgender status, and it doesn't. It turns on sex. The legislature did not want to exclude transgender people from sports. It wanted to keep women's sports women only and exclude males from women's sports.
Apparently, Justice Jackson believes that if someone calls themselves a woman, they really are a woman. Biology be damned. Because even after Mr. Hurst pointed out that the classification is based on sex, not transgender status, she was still confused.
No, I understand, but with respect to two individuals, a cis woman and a trans woman, who both want to play on a team that reflects their gender identity, this law operates differently based on their sex, right?
The law does operate differently based on their sex, as Your Honor just said. It does not operate differently based on their transgender identity.
But it treats transgender women different than cis women, doesn't it?
It has a disparate impact because men who identify as transgender have a different reason for wanting to play women's sports than women, than biological females do, right? But if that were enough, then Skrmetti would have come out a different way, Geduldig would have come out a different way, other cases would have come out a different way. I'm blanking on the other ones.
Justice Jackson's the sex of a transgender woman is still male. Justice Jackson asked Mr. Mupin, amici for the United States, about possible exceptions to Idaho's law.
I'm still struggling to understand why the state would have to have perfectly tailored laws. I would think the state would just have to make exceptions where people can demonstrate that the justification that makes the state's conduct constitutional doesn't apply to them.
I wonder how Justice Jackson thinks that someone could demonstrate to the state that their male child is not physically advantaged by their maleness. Should they go through a drug test to determine the amount of testosterone in their body? And just how often would they have to do that? Is the fact that their performance in a particular sport enough to allow them to take away opportunities for female athletes? After all, isn't that why Congress passed the sex discrimination clause in Title IX in the first place? To prevent mediocre male athletes from dominating female athletes? Should mediocre boys and men be allowed to dominate girls and women's sports, as we've seen done time and time again, just so some minority of people confused about their sex can feel better?